of our overview. So I'm going to go ahead and turn the briefing over to Austin. And while he's chatting, I'm going to put a link to NCSL's summary of the law. And at the end of the link, you'll find a link, another link to the full text of the bill. So Austin, go ahead and take it away.
Thanks, Susan, and good afternoon, everybody. I'm going to start off with the first section of the bill, which pertains to Medicaid programs and adjustments that have been made to the program that relate to increasing mental health services in states, and particularly schools. Typically, this is not an area I cover, but we have a new Health and Human Services Director that had just started today, so we are sparing her this presentation on her first day of work. So I will do my best to outline some of the changes to Medicaid, and particularly the changes to school-based Medicaid that were provided through this bill. So the first section, like I said, did introduce some changes to the Medicaid program to increase access to mental health services through Medicaid. One of the provisions in particular says that the Center for Medicare and Medicaid Services must issue guidance to states on providing telehealth services, and particularly as it pertains to schools, that also includes providing mental health and substance abuse services, substance abuse disorder services to schools via telehealth services. Some other provisions just related to the Medicare program. There's also some direction for the expansion of the community mental health services demonstration program. That's something that up to 10 states can opt into at any time. So these changes to the Medicare were changes to the Medicaid program more broadly, but there were a number of significant changes to the school-based Medicaid program, which have some impact on school safety and student mental health. So by way of background, Medicaid funding in schools is actually the third largest source of federal funding in schools. It's behind ESEA Title I and IDEA funding. It's about somewhere around $5 billion a year. It's something that not every school participates in. In fact, there's kind of two ways that schools can participate. States can provide Medicaid services through schools for helping students to manage their IEPs through IDEA. But beyond that, states can choose to provide Medicaid services for any Medicaid eligible student that might go into that school. So for example, as it kind of relates to school safety, a district could be reimbursed by Medicaid if they happen to hold a meeting with school staff that might determine a mental health evaluation for a student or send them to a mental health specialist. So that's just one of the examples in ways in which a school could take advantage of this to provide mental health services. And school participation rates in the Medicaid in Schools program kind of varies between states. It also varies within states. Not every school participates in a program, even in a state that includes that in their Medicaid plan. And to the extent that a school can bill for certain services is also determined in their state's Medicaid plan. So there's a lot of variance within states. There's a lot of variance between states. But one of the issues with the school-based Medicaid program that have been noted for a while is that many rural schools in particular that wanted to participate in school-based Medicaid services and provide those were unable to, just because they didn't have the administrative capacity to deal with billing issues and a lot of the administrative burden that comes with operating these programs. And so one of the aspects of this bill that really actually pertains to expanding the Medicaid program generally, but particularly I think with an emphasis on student mental health is some particular expansions to the school-based Medicaid program. And so there's a few noted changes that occurred here. So first, CMS has been asked to issue guidance that helps states clarify the steps that they can take, or help schools take steps to bill for any early and periodic screening, diagnostic, treatment service they may provide. There's also a provision beyond that requires CMS to regularly review states' implementation of this screening. That's for the Medicaid program generally, but there's also going to be some additional guidance for that particular screening when it takes place in a school setting. That guidance is also going to include strategies and tools that can help schools deal with administrative burdens and simplify billing processes, and that will help schools. And there's also going to be in addition to this guidance, there's some resources to help states implement this guidance. There's to be a new technical assistance center through CMS that will help states make sure that they're helping schools bill correctly and in dealing with all the different intricacies of the Medicaid program. There's also an additional $50 million, which will go out to states to help them sort of take advantage of this guidance and take advantage of the technical assistance. So kind of the goal here, as I understand it, is it's to make school participation in the Medicaid program more streamlined and simple. And I think the goal there is to provide more mental health supports through the Medicaid program, which I think Congress intends to, have that make schools safer places and provide students with additional mental health services. So that's the first part of the bill. Some changes to the Medicaid program that apply more broadly, but also in the sense of in endorsing and promoting school safety, provides additional mental health supports to students in schools. So that's the first part of the bill. I want to send it over back to Susan for the second portion of the bill and the justice provisions.
Thanks, Austin. So Title II of this bill deals with juvenile issues, juvenile justice, and this law includes background checks for gun purchasers under the age of 21. Juvenile records, including those pertaining to mental health adjudications, are included in the background check. So some of the things that are different or that will pertain to juveniles and young adults, juveniles will receive a unique identifier number when they register. The background check time period for completion is increased from 3 business days to 10 business days. And those are days when the entity that needs to do the background check is actually open. If a prospective buyer has a juvenile, criminal, or mental health record that would disqualify the person from purchasing a firearm under the United States Code, Title 18, the FBI will further investigate that particular record. There's no waiting period for someone under 21 years to purchase and receive a firearm immediately if there are no disqualifying factors in the person's juvenile record. So these provisions will sunset on September 30th, 2032, except if there's juvenile conduct that can prevent a juvenile from purchasing a firearm. The Department of Justice will need to provide some guidance on how these provisions will be implemented. The scuttlebutt around town these days is that DOJ will move quickly on guidance. For example, one question that we know they will need to answer is whether a sealed as well as an unsealed record can be used in background checks. And that will be something that DOJ will have to determine. And these guidance requirements or provisions will come through the Bureau of Justice Assistance, BJA. And then, again, privacy issues have been raised with them already on what does that mean if sealed records are going to be used. So we will have to wait and see. But, as a state, we are stakeholders in this process as we will have to deal with implementation. Other provisions that aren't juvenile related establish new laws pertaining to straw purchasers of firearms and firearms traffickers. So straw purchasers now face enhanced penalties of up to 25 years imprisonment when a straw purchased firearm is used in connection with serious criminal activity such as terrorism or drug trafficking. Firearms traffickers face an enhanced penalty of up to 15 years imprisonment. Investigators now have additional wiretap, forfeiture, racketeering, charging, and criminal fines authority, which are all detailed in the statute. Federal law is also expanded to include the crime of smuggling firearms out of the United States. Previous law only applied to criminalized smuggling of firearms into the United States. So now entering and exiting with firearms is now criminal activity. The law also contains domestic violence provisions and closes, to the best that they could, what's known as the boyfriend loophole. Federal law now defines a misdemeanor crime of domestic violence as including individuals who have or have had a current or recent continuing serious relationship of a romantic or an intimate nature with their victim. Previously, this definition only applied to spouses of or people with a child in common. So now that definition has been expanded to include non-marital relationships. The new definition, however, is not retroactive. It only applies to current or recently ended relationships. If a person is convicted of a misdemeanor crime of domestic violence, their right to purchase a firearm will be automatically restored 5 years from the end date of their criminal sentence if they have no further crimes of violence with a conviction. One piece of information or provision that is not contained in the legislation, except as an option for states to spend appropriated dollars, is colloquially the red flag laws or the extreme risk protection orders. Antiguan tracks that information for NCSL, and she tells me there are 19 states plus the District of Columbia that currently have IRPOs in effect. Whether there will be more states that choose to use their appropriated dollars to do this remains to be seen, but it is not a mandated provision in the text of the law itself. There was differences of opinion on whether that should be included or not. So turning now to appropriations, there are also quite a number of them contained in this law in both the justice, education, health, and human services areas. All of these areas have received appropriations. And for all of these grants, the law establishes a new federal clearinghouse on school safety and evidence-based practices. This clearinghouse is charged with setting up a website for best practices regarding school safety, but it also is charged with reviewing all of the grant programs and identifying evidence-based practices for which there is not a current federal grant program. So I'm going to go through the Department of Justice and the HHS, the Health and Human Services provisions pertaining to the appropriations. And I'm just going to take a moment here to share my screen and put my slides up here. Give me just a second. Okay, can you guys see that?
We can.
All right. Okay, thank you. So the Department of Justice funding, most of this funding is to be done over a 5-year period. And in addition, so the first one is $750 million for crisis intervention programs under the current Burn JAG formula grant setup. And this 750, I want to clarify, is in addition to whatever your state currently receives in Burn JAG funding. It's mandatory spending. It does not need to be appropriated for state crisis intervention programs. And I want to draw your attention to the word state, which I did not put in the slide, but that is indeed in the bill, in the law. This money goes directly to the state. It does not go to localities within your state. So the state receives its portion of the $750 million over 5 years. And I will tell you, Senator Cornyn from Texas, who was the chief Republican negotiator on this bill, wanted this program to go directly to the states, recognizing that the states have the capacity to handle the influx of dollars, and that the locals, if you recall, receive 60% of Burn JAG allocations to begin with, whereas states only receive 40%. So this additional percentage will go directly to states. The funding can be used for a variety of purposes under Burn JAG, which would be left to the states. Some functions named as examples in the law are mental health courts, veterans courts, drug courts, extreme risk protection order programs, which I mentioned earlier. So that's an option if your state chooses to use that funding for that purpose. If the state does use the funds for extreme risk protection order programs, those programs must include a bevy of requirements to ensure due process is met. And some of those requirements are pre and post deprivation due process, the right to be represented by counsel, pre and post deprivation heightened evidentiary standards and proof, and penalties for abuse of the program. The Attorney General is also required to publish an annual report on the grants awarded for the state crisis intervention programs, and it is broken down by grant recipient. The report from the AG must evaluate the effectiveness of all of the programs and discuss the measures taken to ensure that the constitutional rights of individuals involved in crisis intervention programs are protected. The term itself, crisis intervention, will be broadly written as I understand it. For example, it could be interpreted to include training in threat assessments for court personnel by a trained medical doctor, or other professional. Other grant awards you can see there on the screen. 300 million for Stop School Violence, school safety programs, 250 million for community violence intervention programs. The FBI one is one-time deal for FBI agents. So that is essentially the justice program funding. And now I'll turn to the next slide here, if I can. Whoop. There we go. Okay, so this is the Department of Health and Human Services funding. And again, I'm not a health and human services expert, but wanted to make sure that those folks on the call that were interested in this type of funding could see where the money was going. 250 million over 4 years for SAMHSA, Community Mental Health Block Grant Program. 60 million over 5 years for training in mental health. And 80 million over 4 years for HRSA to support pediatric primary care providers. And then the rest of that funding, again, for SAMHSA to train and prepare the community members and first responders on how to respond to folks with mental health issues, 40 million for the National Child Traumatic Stress Network, and 150 million in one-time funding to support implementation of 988. So now I will flip it back over to Austin to talk about the Department of Ed funding.
Thanks, Susan. There's also some appropriations to this bill for Department of Education grant programs. All of these programs are existing programs that are currently in operation. The funding will be available through March 1st of next year. The biggest pot of funding that's getting an increase is what's called the Student Support and Academic Enrichment Grants. It's the Title IV funding under the Elementary and Secondary Education Act. That's funded on an annual basis. It's about, I think it's been recently getting about $1.4 billion a year. So this bill would add an additional $1 billion for this year. And how those funds work is they flow through states to local school districts, and the school districts in typical times have to allocate their funding across 3 different programmatic areas. This funding would all go to one of those programmatic areas, which is the Safe and Healthy Students Program. Essentially, what that does is that school districts select from a large list of allowable activities that relate to school safety and student mental health. These are all locally determined programs. So among those programs can be drug and violence prevention programs, school-based mental health services, bullying and harassment prevention programs, reentry and transition programs for justice-involved youth, mentoring and school counseling, school-wide positive behavioral intervention supports, as well as training for school personnel and trauma-informed practices. So the allowable activities under this particular funding stream are really broad, and something that every school is currently allocating funds for, at least every school that receives that. And typically, if it's a Title I school, they will be receiving funding under Title IV. So $1 billion there. There's a small portion of funds, about $50 million, going to another program under ESEA Title IV, and that is the 21st Century 21st Century Community Learning Centers program. That essentially is a program that provides opportunities for high-need youth to participate in activities and non-school hours that provide academic enrichment and youth development. So I think this is considered a small investment in another way to address student mental health. Then there's $500 million each for 2 recently created school health programs. These were created, I believe, in 2019 by the Trump administration. They've each received 1 round of funding. I believe this is the second round of funding they will receive. That first grant is the School-Based Mental Health Services Grant. It's going to receive $500 million. Essentially, that will be competitive grants to states with the goal of increasing the number of qualified mental health service providers or reducing turnover within that field. I think the last time that a grant program for this was operated, or at least the only time it was operated, I believe 27 states received awards. The Department of Education will have to put out a notice inviting applications for this process. I would expect that to happen fairly soon, but I don't have any updates on the implementation of that program. Similarly, the department will also have to put out an NIA on the School-Based Mental Health Professionals Demonstration Grant. which is basically an investment in improving the pipeline of mental health professionals. And this grant program supports partnerships typically between institutions of higher education and school districts to prepare school-based mental health service providers for employment in high-need schools. So these are all existing programs, but a little over $2 billion going through the Department of Education to support school safety efforts in schools. So thanks. Back to you, Susan.
Oh, okay. And up on your screen, you see the school-based Medicaid provisions here as well. And I'm gonna go ahead and stop sharing. There we go. Okay. So now we're going to turn it over to you guys. If you have any questions, feel free to unmute yourself and fire away, or, you're welcome to type your questions in the chat. We do await agency guidance on a lot of this stuff. So implementation is, we don't have the letter on that yet. But one of the things that we do know is that all of these agencies want input from as many of the stakeholders as possible to help them guide the direction that this implementation language will take. So wanted to also use this opportunity to get some feedback from you guys to see if there's any areas you'd like us to address with any of the agencies involved. We know that there's been a lot of state activity prior to this becoming law on little pieces of this, issue, this bigger issue of school safety and gun violence. But if there's anything that you've heard today that you'd like further clarification on, this is your chance to fire away, and we'd be happy to take it back to the federal folks who are working on this. And if not, you guys get back 30 minutes of your time. Oh, we got one. Yes, sir.
Thank you, Susan and Austin. Just a quick question on the Title IV Part A money. Is that going to go out through the normal, Austin, I see you smiling, unsurprising that this is what I would ask for. Do you know, is that just going out sort of the normal distribution route, or is that going to, it wasn't clear to me reading the bill whether it was just going to go to states and they were going to offer it, or is it going out through the normal formula written in ESSA?
Great question. One I was thinking about that I thought might be asked, and it's no surprise that you're the one asking it. I don't have an answer on that. I can certainly follow up. My expectation, just because this is emergency funding, I would presume that they would try to use existing, grants management systems to send this out. So I wouldn't anticipate that there would be, additional, processes for doing this, and they try to send this out through regular order. But that's speculation on my part. I don't have a definitive answer there.
Thank you. That's kind of where I was too. And then the only other question, more sort of on the NCSL side, do you all have any materials or clearinghouse? We had a bill that came through my committee last year unsuccessfully, but we've been trying to work with our higher ed system to create a better pipeline for mental health providers, not only for K-12, but frankly, who can provide services in higher ed as well. Any documents or research that you all have done on what other states have done in terms of best practices to increase that pipeline?
We have some resources. I can gather those maybe quickly and put them in the chat, or I can follow up with you directly. We do have, we've had a number of different resources that we put together after a number of the different tragedies that have occurred in schools over the years, and have sort of had sessions at our conferences and other gatherings after that. So there's been a stream of materials, and that's run through our state staff on the education side, but I know we have those, so I'll try to gather those while we're here. If not, I can send those later. But if you for anyone that's listening, you probably just type in school safety and NCSL into Google, and that should get you there. But I will try to pull those up really quickly.
Thank you, Austin. Thank you.
Oh, I see one question in the chat here related to extreme risk protection orders. Does the bill restrict the standard of proof states can use for these, or allow grant funding only to states with a high standard of proof for ERPOs? And my response to that is there's no restriction on the standard of proof. It just has to be, I guess, such that due process is met. There are specific provisions for due process that are contained in the law. It's a lengthy and extensive list, so I urge you to take a look at that. Grant funding will come through your burn jag formula grant. So, and using it to establish an ERPO system or requirement would be through that funding. So there's nothing that says that funding would be contingent on meeting certain standards. A state would have to be certain that what it has in place meets the standards that are contained in the law, but the funding, it's discretionary. So at the state level, so you can use it for one of a number of different purposes. I hope that helps. I'm happy to take that one over to the agency as well to get clarification.
I see a question in the chat about funds going through the Department of Education. I would think that the funds would be available to be obligated through March 1st of 2023, but then there's usually, and this will be specified in some of, it depends on which of the programs we specified in the grant application, the spending timeline that states and schools have to spend those funds. But as I would understand it, the funds would go out, and districts, once they receive them, would have until March 1st to think about how they want to spend them. And then after that March 1st deadline would have a period of time in which they would draw down those funds for whatever expenditures they had chosen.
Yeah, I would agree with that. I think that's up to the agency. My guess is that if they're using existing funding streams that are already in place, at least for the justice grants, many of those are formula grant funds. And so I don't think they're creating, at least on the DOJ side, any new funding mechanisms or funding streams. So I think once the money is there, it can go out pretty quickly if it's just going to go through the established formula that's already in place.
And Susan, I was just going to mention that I am the contact for extreme risk protection orders. I also I am working on an update right now to my long memo, but I'm kind of balancing waiting until there's more federal guidance. So, there may be I may be updating the information as I get it, or I may just decide to use the language in the bill. I haven't decided yet. So if either of you guys, if anyone has any preference, please let me know.
Thanks, Anne. Any other questions? Feel free to email us. Most of you know how to get in touch with at least one of us on this briefing. So if you think of things later on, let us know, because we want to have that direct communication with you. We also want to be able to bring forward your questions and concerns to the relevant agencies to make sure that whatever guidance is going to come out makes sense at the state level. So I see no other questions. You guys get back 27 minutes of your day. And I really do thank you. We all thank you all for tuning in to this briefing. We have, again, the links in the chat to the summary and the bill text, which has the bill number and the passage votes and all of that. You can see all of that there. And as we move forward in this process, we'll be sure and keep you updated. And we'll hope that everything works out for the best in terms of state implementation. But thank you.